Good morning, everybody. We have a few people still making their way in from the waiting room, but I think I'm going to go ahead and jump in with our Zoom housekeeping tips. And I'm just going to remind you that your Zoom toolbar is at probably the bottom of your screen, and that's where you will find your audio or mute and unmute buttons, as well as your start and stop video buttons. As a general rule, we do ask people to stay muted during the Zoom unless you want to unmute yourself to ask a question, which you're welcome to do. But otherwise, if you could stay muted, that helps to minimize background noise, makes it easier for everybody to hear. If you want to have your video on so that we can see you, we always love to see your faces. But if you need privacy or you're having a bad hair day, listen, I've been there, so you can keep the video off, whatever makes you guys feel comfortable. The Zoom toolbar is also where you will find the chat button, which might be flashing right now because I put a message into the chat. The chat is the best way to ask questions today or to request clarification about something that we've said during the Q&A. And the message that I put into the chat does give you the information about how to email us your questions in advance of next week's Q&A. So if we don't get to your question from the chat today, please copy and paste it into an email to info@condowa.net so that we can, there's nothing in the chat. Well, let me put that in there again so that we can put that on our list of questions for next week. All right, we'll put the message into the chat again. And I just did that. So Sandy, if you don't see it, I don't know what's going on, but I did just put it in there again. I think sometimes when you join after the message has been put into the chat, you don't see what was there before. So speaking of the chat, we tell you guys this every week, which is probably not necessary because y'all are very well behaved in general, but it's not a place to like argue with each other or get into big discussions like you might see on the CAI message boards. That's a great place to go if you want to have those kinds of discussions. But the chat, we do like to see it reserved for questions or requests for clarification. Another thing that we do remind everybody about every week is that we are here to give general legal information, not specific legal advice. So one of the questions that came in for this week that I had to send to Chelsea and tell her to email the person that it was too specific was, you know, a big paragraph long excerpt from a community's bylaws and very specific questions about the application of those bylaws. That's legal advice. We can't do that here. So whenever we see questions that are too specific like that, sometimes we just can't cover them at all because they're too specific. Other times we'll try to at least cover the subject matter generally when we can and when we think it's, you know, broadly applicable and helpful. So please do just keep that in mind. And the sort of complimentary advice on that is if somebody sends you one of our videos and says you have to do this thing or you can't do that thing because of something that Jennifer or Ken or I or one of our other associates have said, you can ignore them because it's not legal advice. All we can do in this forum is talk really generally about things, and your mileage may vary, as you know, as I see a lot of younger folks saying. So the reality is we talk about things very generally here, but how they would apply specifically in your community can vary widely depending on what type of community you are, what your governing statute is, what your governing documents say, etc. So please keep that all in mind. We have been reminding everybody about the Corporate Transparency Act. We are still telling our clients right now that it is okay to wait a couple more months before taking steps to comply with the CTA. We are all crossing our fingers that something at the national level, one of the many efforts that are happening, will result in either a stay or a delay in the effective or implementation date of the CTA, at least for HOAs. So stay tuned, watch this space. We are monitoring all of those different things that are moving at the national level, and we'll update you either when we think, gosh, it's time to comply, even though it still might happen before the end of the year, or when one of those efforts at the national level results in some relief for HOAs. I found out yesterday when I was searching something on the legislative website in WUCIOA that the legislative website has now been updated to reflect the changes from the 2024 legislative session. So if you search up a section of WUCIOA or your, you know, Condo Act or whatever your governing statute is, previous to this, any section that had been changed would have the old text of that section and a highlight at the top that said changes in 2024, linking you to the bill that changed that section. now the actual current text of the statute as it was amended in 2024 is showing up when you do those searches. So that's good news. And finally, we want to remind everybody that we are not doing a Q&A on August 14th. So obviously that's a few weeks into the future, but we're going to remind you about that each week just so you guys can do planning. And I think as far as announcements go, that's all I've got. Unless you have anything, Jen, I'll jump into the questions.
No.
Okay. All right, here's our first question. Is there a law that requires an attorney to review an amendment to the declaration before publishing vote from the homeowners? So the wording of this question is a little confusing to me, but I think essentially the question, as I would paraphrase it, is, do we have to have a lawyer review an amendment to the declaration before we put it to the vote of the owners to amend our declaration? And the short answer to that question is no. There is no law that requires that you have a proposed amendment reviewed by your attorney. However, and this is, I'm sure those of you who come to this Q&A often are not surprised by what I'm about to say. In our experience, amendments drafted by lay people or even attorneys that don't have HOA specific experience often contain errors and can have significant unintended consequences. So for example, I'm going to give you a very specific example. We had a client that came to us with their original declaration and a whole series of amendments. And at one point they did a restatement, and the restatement, as it should, essentially wiped out all of the previous provisions and covenants and conditions, etc. So it said it in the text of the restatement that essentially this document replaces everything before it. Everything before it is erased and no longer exists, right? Well, then somebody decided it would be a great idea to use the restatement and essentially copy and paste for every subsequent amendment that that client recorded for their declaration. The problem is, whoever did that did not remove the language that wiped out all previous provisions. And so every time they recorded an amendment, it essentially erased all of the covenants, conditions, restrictions, provisions, etc. that had been recorded before, so that the only thing that was sort of left standing was the text of the current amendment. And so obviously that was a very significant and very much unintended consequence of someone who did not understand what they were doing, drafting and recording amendments. So another thing we sometimes have clients ask us that's related to this is, what if we draft an amendment and then just have you review it for us? We are perfectly happy to do that, but I will be frank and tell you that generally the cost of having an attorney draft the amendment to begin with is almost always lower than the cost of having us review and then fix an amendment drafted by a layperson. So I think you just need to be very careful about adopting amendments that are drafted by lay people. At a minimum, you should absolutely have them reviewed by an attorney, not just any attorney, by an HOA attorney. And in a perfect world, I think amendments should be drafted by community association attorneys, because there are a number of sort of technical things that are supposed to be in each amendment. For example, a recitation of all previous documents that were recorded, including whether the survey map and plans have been amended, and the recording numbers for all of those previous amendments, both to the declaration and to the survey map and plans. And frankly, sometimes those things are complicated and weird enough that we have a little bit of trouble getting them correct. So I just want to remind everybody, if you could stay muted, I think somebody maybe accidentally unmuted there. That would be great. So as to the actual vote on the amendment, one reminder is that you have to send the actual text of the proposed amendment to your ownership before either the meeting to vote on the amendment, or if you're voting by mail, that's fine too, but you have to send them the actual text of the proposed amendment. The other thing that I will say that I almost forgot to mention when it comes to having an attorney draft an amendment for you is that you are shifting risk, right? If there's a mistake in the amendment and your attorney is the one that drafted it, we have malpractice insurance to cover any consequences of that mistake. But if you make a mistake, there is no such shifting of the risk if you have not worked with an attorney on that. So I just think there's too many examples of people doing amendments without the assistance of an attorney where either minor or huge mistakes have been made, even things that violate statutes sometimes accidentally sneak in. And as my mom says all the time, and Jen put it right in our prep, just because you can doesn't mean you should. So there's no law that says you have to have an attorney review it, but I think there's a lot of very practical reasons why you should. Jen, do you have anything to add to that?
Just briefly, pay someone to have it done right the first time. And as Valerie said, just because someone is an attorney doesn't mean they have the background or knowledge with community associations and how community association statutes work to actually do this. In our prep before the meeting, Valerie said something about how you can read a chemistry textbook or a biology textbook, or even look at a map of someone's organs or bones, but that doesn't mean you're competent to set a broken bone. Another example that we use is you wouldn't ask a ear, nose, and throat doctor to do surgery on someone's knee. So just because someone's an attorney doesn't mean they have the actual knowledge and ability to do an amendment properly. Moving on to our next question. And if you can't tell, that's one of our soapbox issues. So the next question is, our association falls under 6438. Reading this section regarding proxy voting is very confusing. When can proxy voting be offered? Can a board decide if they want to offer proxies, or does the statute make it mandatory to offer it? So the statutes that apply, and these are the all of the statutes: 6432 280 sub 5, 6434 340 sub 5, 6438 020 sub 5, 6490 455 sub 3.
Now, don't panic, anybody. I put them into the chat. Sorry to interrupt, Jennifer.
No worries. Now, if you just in that quick recitation and then in the chat, you can tell that the old four statutes all have the same subsection, but WUCIOA is different. Now, they used, I think the legislature first amended the statute in 2021 to make them all the same. This year, they amended WUCIOA to make changes. So now WUCIOA is different from the other statutes. So if you're under WUCIOA, pay close attention to that. If you're not now, you will be in 3 years. So just kind of keep that in the back of your head, that WUCIOA is different, and you might want to take a look at it and see what those differences are. So just briefly, unless your governing documents prohibit it, proxies must be allowed. So the statute states in part, except as provided otherwise in the declaration or organizational documents, the following requirements apply with respect to proxy voting. So that's a carve out that the legislature makes, and God knows it's wordy enough as it is. But it means that the governing documents can say something different, and then the governing documents apply, and the statute doesn't override that. But the board doesn't have to provide proxy forms. If an owner gives you a proxy, gives a board a proxy that complies with statutes, it must be allowed, but the board doesn't have to provide it. You can offer proxies to get more participation. It's a board decision. You cannot reject proxies unless the declaration specifically states no proxies are allowed, or the proxy doesn't comply with statute. And then just a general comment, we don't understand why boards would not want to allow proxies. You have enough problems trying to get participation for elections, or heck, even getting quorum at annual meetings. Proxies count towards quorum. So we don't understand why you'd want to do this. Technically, you can if it's already in your declaration, but if it's not, and the proxy is complies with statute, it must be allowed. Valerie, did you have anything to add to that?
My only comment would just be to emphasize that last thing that you said. We have so many clients that can't conduct elections, can't get the votes they need to pass a declaration amendment, cannot get enough owner participation to do things that the association wants to do, that I am confused about communities that want to find ways to reject valid proxies. And you can't have it both ways, right? You, the proverbial you, I'm not like directing these comments at the person who submitted the question. But if you're struggling to get enough owner participation to do the things that you want and need to do on the one hand, but you're looking for ways to reject proxies on the other hand, those two things are not incompatible. If you make it harder for people to vote in certain situations, they're going to be less likely to vote in all situations. So I think that rejecting proxies or refusing to allow proxies is generally a bad idea. And I don't know why a community would want to do that. I also did want to offer one other comment, which is Jennifer is absolutely right that the only way you can refuse to accept proxies is if your declaration says that. And the only way to start refusing proxies, if your declaration doesn't say that, is to amend your declaration to authorize you to prohibit proxies. So keep that in mind. And with that, I'm going to move on to the next question. Washington State Senate Bill 5796 looks like it has a few effective dates for its changes. It looks to me like the June 6th, 2024 changes are all for just WUCIOA communities. The January 1, 2025 changes are for just WUCIOA communities. And the January 1, 2028 change is for all communities to comply with WUCIOA. Is that correct? Or is there anything that will affect those under other statutes sooner than January 1, 2028? I think your summary is absolutely correct. The changes that took effect this year and the one change that takes effect next year, those changes only affect communities that are currently subject to WUCIOA or that adopt it between now and next year. And the WUCIOA for all part of the bill, which is the only part that affects communities not currently governed by WUCIOA, doesn't take effect until January 1st, 2028. So non-WUCIOA communities can largely ignore these changes until then, or until they choose to adopt WUCIOA if they do that sooner. The legislative website, like we mentioned, has now been updated. So all of the statutes and any of the changes made to them are reflected when you do the searches for the different sections that you're looking at. And in case it's helpful to know this, some people are confused about the change in 2025. Like, why would one thing change in 2025? The change that's going to happen in 2025 is essentially dates back to the foreclosure protection and foreclosure procedures changes to WUCIOA and to all of our governing statutes, actually. So because those changes were prompted in part by the financial struggles created by the pandemic, there were waiting periods that were longer that will expire on January 1st of 2025, and they will be replaced by slightly shorter waiting periods before we can file a foreclosure lawsuit. And that timeline was just in recognition of the fact that the financial repercussions of the pandemic are mostly gone, or will be mostly gone by 2025. So that's just something to keep in mind. The other stuff that's out there, things like requiring associations to allow heat pumps under certain circumstances, EV chargers, those kinds of things, those were changes made to all of the governing statutes. And so those ones are not part of the bill that we're talking about here, but those ones did take effect this year and are not delayed in their implementation. Jen, did you have anything to add to that?
No, I don't. So the next question is, what if the declaration states that the annual meeting needs to be held at the first quarter of each year, but it was missed? Can this be rescheduled sometime that year, or do you just proceed with next year's annual meeting? So by statute, and this is in the Nonprofit Corporations Act as well as the Common Interest Community, so the usual 6430 statutes, associations must have an annual meeting. When that meeting must be held is usually in the governing documents. If you've missed when the meeting was supposed to be held, call for a meeting as soon as possible. If an owner challenges this in court, the remedy is to hold an annual meeting. The only caveat is that if you called for a meeting and did not reach quorum, that still counts as your annual meeting. You're fine. You don't have to call another one. But if you completely missed when your annual meeting was supposed to be held, call for one as soon as possible. Get that done, get it on the books, and just move on. Valerie, did you have anything to add to that?
Nope, I think you covered it. Our next question says, you mentioned HOA amendments needing to be recorded by the HOA with the county for record purposes. Is it the same for bylaws? What is the difference? Is it that the amendments are a change to the CC&Rs and the declaration? So I think it's helpful as a reminder for those who have been doing this for a while, and as a primer for those who are new to this area of information, to clarify the difference between the variety of governing documents. So the term that we use, governing documents, is an umbrella term that includes all of the organizational recorded and unrecorded documents for communities. So this would include your articles of incorporation, your declaration, or CC&Rs. Those two terms are interchangeable. Your bylaws, you have rules and regulations, collections policies, etc. That's all the governing documents, right? Generally, your declaration or CC&Rs is the only document that is required to be recorded with the county in which the property is located. And any amendments to the declaration or CC&Rs must also be recorded in order to be enforceable or to be enforced. Declarations and bylaws are supposed to have different information in them. And I say supposed to because we often see documents that mix up the stuff that they have in them. Things that are supposed to be in the declaration might be in the bylaws and vice versa, okay? But in a perfect world, the declaration would contain provisions regarding the ownership of the land, the rights and obligations of both the association and the owners. It binds all present and future owners to those restrictions, etc. And your bylaws are supposed to contain provisions about governance of the association and how it runs as a corporation, okay? So if you wanted to adopt a rental restriction, that belongs in an amendment to your declaration that is recorded with the county. But if you want to change the procedure for calling a special meeting of the board, that belongs in your bylaws. Most of the time, bylaws are not recorded, and legally they are not required to be recorded with the county. So occasionally we do run across a client that has had its bylaws recorded for some reason. And, we never really know why, because usually it's quite some time in the past. Most of the time, what we do when we're working with those clients is we prepare a document for them that's called a rescission to be recorded against the original recording number of those bylaws. And that basically rescinds the recording of the bylaws, which then means any future amendments don't also have to be recorded. But if you don't do a rescission and you're amending your bylaws, then you do need to record the amendment since the original was recorded, right? I also want to clarify terminology here. So recording is something that you do at the county level with the recorder's office, and it records the document that you're recording against the parcel number. If it's a lien against one unit, for example, that would be recorded against only the parcel number for that unit. But if it's an amendment to the declaration, that would be connected to both, number one, the master parcel number for the community when it was developed, but also the recording number for the declaration. So that in theory, if somebody all they know is the recording number for the original declaration, they should then be able to find all the amendments that are related to it in the county records, if it was indexed properly by the county. Articles of incorporation are different, and those are filed with the Secretary of State, not with the county. So that's your sort of description of the variety of governing documents. Somebody asked in the chat, I think essentially is, what's the cascade of authority, right? What's the hierarchy here? So I'm going to say, in general, this is the hierarchy of authority that community associations deal with. Any federal statutes are first and trump everything else. Then any state statutes that apply to your community. And don't forget that this does not just include your particular governing statute, HOA Act, Condo Act, whatever, but it also includes the nonprofit corporation statute that is applicable to your community. Generally, then, your declaration is the highest authority within your governing documents, although depending on the issue, the articles of incorporation can sometimes trump. Not necessarily the declaration, but certainly the bylaws. They can trump the bylaws. Most of the time, the articles of incorporation are very short and don't really say anything, but we can never make that assumption. So anytime we're drafting amendments, anytime we're drafting rules, anytime we are drafting a collection policy, anytime we're drafting or advising our client really on anything to do with their organizational documents, we always at least glance at the articles just to make sure there's nothing substantive there. Assuming that there isn't, the hierarchy of your governing documents typically is declaration has the most authority, then bylaws, then rules and regulations, policies, etc., are below that in the hierarchy. So I think, again, going back to the question is what needs to be recorded. Generally, it's just the declaration and then any amendments to the declaration. But if your bylaws were recorded, you either need to rescind that or you need to record any amendments so that you've got all the documents recorded, or sorry, all the amendments recorded related to the original. I think that covers everything, but Jennifer, if you have anything to add, please do.
I don't. The next question, we are an over 55 HOPA condominium, and this is clearly stated in our governing documents and resale certificate. When a unit is being sold, does either our association or the unit owner have a further obligation to notify a potential buyer of the age restrictions and number of units available for under 55-year-old residents? So not necessarily. The obligation is generally on the purchaser or their realtor to read the documents and check that the potential purchaser complies with the over 55 restrictions. There are times when a child purchases a unit for their parent, and the way that the HOPA statute reads is as long as at least one occupant in the unit is 55 or older, they comply and count towards the 55 and older restriction. So the resale certificate probably meets the association's obligation to notify potential buyers. You may have signage or other marketing materials that identify the community as a HOPA community. But one thing that people need to remember is that to retain HOPA status, the community is supposed to inventory or poll basically the residents every 2 years to ensure that at least 80% of the units have one occupant 55 or older. So if you have not done this for a number of years, do it as soon as possible. You may not have to basically renew your status, but make sure you have the record keeping available should someone ask so that you can retain your 55 and older status. Valerie, did you have anything to add to that?
Yeah, I think it's worth emphasizing that in Washington state, when you sign a contract, it doesn't matter if you've read it or not, you are bound by the terms of that contract. And similarly, when somebody purchases a piece of property that has deed restrictions, including the 55 and older situation here, which is very clearly spelled out in the governing documents, they don't get to avoid those restrictions by coming back after the fact and saying, well, I didn't know it was a 55 and older community because it was in the documents that you disclosed to them as part of the resale certificate. So you do want to make sure that all of your governing documents are attached to your resale certificate and that the resale certificate clearly discloses HOPA status. And then if you have somebody come back after the fact and say, well, I didn't know, then that's when you escalate it to your association attorney who can help you with this scenario. But I think it really doesn't hold water.
So the next question, I have a question about the storage of e-bikes on condo property in terms of the hazards of batteries causing fires. Are you seeing house rules on storage of e-bikes as a result? So there's been a lot of information on this on the CAI message boards. From what we've seen, the issue with fires and e-bikes is mostly from overcharging off-brand lithium-ion batteries sold by second parties that have not been thoroughly screened. This is typically not an issue with name brand reputable companies that produce batteries. If your community is concerned about this issue, you can craft a short, simple set of rules regarding storage and charging of e-bikes in the common and limited common elements. You generally cannot regulate what an owner does inside the unit unless the authority for that is in the declaration. We'd strongly recommend having a community association attorney review the rule or review, frankly, any set of rules, because we've seen so many that don't comply with statute or don't comply with the governing documents. But have an association attorney review your rules to make sure they're enforceable and are correct. Valerie, did you have anything to add to that?
No, I think you covered it. So moving on to our next question, can you speak to the topic of what banks and mortgage lenders look for with respect to reserve funding percentage or annual contribution amount minimums that they want to see in Washington state in order to grant mortgages on homes within a community? So first of all, I'll offer that our comments on this topic are applicable across the board, regardless of whether you're an HOA Act community, a New Act community, a WUCIOA community. And I'll say the starting point that most lenders look at the federal level is that 10% of the annual budget or more, a minimum of 10% of the annual budget should be contributed to reserves. And there have been a lot of changes to how banks look at community associations and their finances as a result of the Surfside condominium collapse that happened a few years ago. And we have had clients where people have had trouble securing.
Oh, looks like Valerie froze. Oh, there you go. Valerie, you froze for a moment.
Oh, okay. So where did I leave off?
When the association had trouble securing more mortgages.
Yes. So we've had clients where people have had a hard time getting a mortgage to buy or refinance within the community due to being poorly funded. So banks look at a number of different things, one of which is 10% or more of the annual budget being contributed to reserves. They look at deferred maintenance and whether there is a chance of a special assessment. And the question of what a reasonable amount is for a community to contribute annually to its reserves is not one that we can give a blanket answer to in the context of this Q&A, because it matters a lot. How old is your community? How many common elements is the association responsible for maintaining and repairing and replacing? How well funded are your reserves historically? How well maintained is the community? It might be 30 years old, but if you've been very proactive and you get a reserve study every year and you adequately fund it and you do repairs in a proactive manner, that's very different than a community that hasn't had a reserve study in 5 years, or that's got a current reserve study now and is contributing at a healthy rate now, but that's got 20 years of deferred maintenance. So there isn't a one size fits all kind of cookie cutter answer to the question of what lenders look at. We can talk to you about some of the factors that they look at. Other things that banks look at, which are not reserve related at all, include your overall delinquency rate. Sometimes they look at things like the percentage of owner versus tenant occupied units. And so Jennifer put a link into the chat from the Freddie Mac website. And as many of you may know, Freddie Mac and Fannie Mae back a lot of mortgage loans. And so a lot of traditional mortgage lenders, even if they aren't actually Freddie Mac or Fannie Mae, will adopt the same standards as Freddie Mac and Fannie Mae. And so that's just something to keep in mind. And there were some comments, if you go to that website, that are helpful in terms of how a seller can rely on a reserve study, what the reserve study has to include in terms of like its financial analysis, the annual reserve funding plan, how frequently it was updated, etc. So if you go to that link, there's a lot more information there that could be helpful to you in answering this question. Now, again, going back to the question of what is the percentage or annual contribution minimum, beyond giving you that 10% of your annual budget, there isn't a lot more that we can say that is going to be super helpful to your specific community because of all the variations that I mentioned earlier. Jen, did you want to add something to that?
No, I think you pretty well covered it.
Okay.
Well, actually, one quick thing, and there was a comment in the chat about a reserve specialist suggesting associations have at least 70% funding. That number may be different for other communities. The level of funding for your community is an extremely specific number, community to community. So what fits one association may not fit yours. So contact your association attorney. Remember that the reserve study is a tool used for planning. It's not a you must do this. So even if the reserve study says that your roof must be done in 3 years, if you get a contractor or roofing specialist to come in and say, this has 5 years, you're fine. You're able to rely on that information. So this is not a one size fits all.
Yeah, I think that's a great point. Your reserve study is a spending plan, a saving plan, and a spending plan. It's not a maintenance plan that's set in stone. I also think it's important to recognize the difference between the 70% funded is about what level your particular reserve account is funded at in the context of your specific reserve study. The 10% that we were talking about is the national standard for lending that looks to see if 10% or more of your annual budget is being contributed to reserves. That's a completely different number from how well funded your reserve account is. And we could spend an hour talking about the different funding levels of a reserve study. And so that is outside of the purview and the time that we have here, but just keep in mind that there's a difference there. And if your reserve study professional is recommending a particular level of funding to you, we think generally they're the experts and it's a good idea to comply with that recommendation. And if you have questions or concerns about it, consult with an attorney that is both familiar with condo associations, HOAs, whatever, but also that has some knowledge of building components, useful life, etc., because they can help you interpret the reserve study and understand why your reserve professional is making the recommendations that they are. And there's a clarifying question in the chat, 10% of the annual budget, does that mean the operating budget? And the answer to that is yes. So if your budget as an association for the year is $1 million, just because that's an easy round number, I know that most of them are not quite that high, then they're going to be looking to see if you're contributing $100,000 of that budget to the reserves in any given year. But I also think it's important to note that they're not looking at that number in a vacuum. Like I said earlier, if your reserve fund is underfunded and you've got 20 years of deferred maintenance, the fact that you're contributing 10% of your annual operating budget to the reserve account, that alone is not necessarily going to make your community loan worthy. So again, too many complex issues. I don't want to keep talking about the same topic. We've got other questions to get to, but I think that covers that for now.
Okay, the next question is, at the very end of the Q&A on June 26th, Valerie mentioned that in the past, the board would not be involved in homeowner to homeowner harassment claims, but now that was no longer the case. Can you please explain this in more detail? So there was an FHA ruling, and this is the Federal Fair Housing Act ruling in 2016, that associations may be liable for harassment perpetrated by one homeowner on another if the association knew of the harassment and failed to exercise what little power it has in an attempt to stop the harassment. So one thing every community can do to be proactive about this is to adopt and enforce an anti-harassment policy. So just general takeaways on this. If an owner or resident in your community is harassing, threatening, whatever, another homeowner or another resident, the board must investigate. And if you have enforcement procedures, you must follow those procedures. You cannot just ignore this. Valerie, did you have it? Oh, Valerie put some information in the chat. And this is all regarding fair housing. Please remember that while the ADA does not apply to most associations, the Fair Housing Act, or FHA, does. And this, the Fair Housing Act, basically prohibits discrimination on the basis of race or sex, religion, national origin, etc. Disability is another big one. So when it comes to homeowner disputes, before 2016, we were saying this is homeowner to homeowner, the board doesn't need to get involved. That's different now. And the board should at least investigate the complaint, and if you have enforcement procedures, follow them. While this may not prevent a Fair Housing Act complaint, it will certainly help in finding that the association did what they could, and hopefully you won't have to do much further with the Human Rights Commission. Valerie, did you have anything to add to that?
Yeah, not at the risk of sounding a little bit too much like a Pollyanna, I think it's also the right thing to do. In particular, when you know that harassment is happening due to someone's membership in a protected class, there's a reason that our laws protect people in those communities. And it's the right thing to do when you become aware of that type of harassment, to do what is possible to try to stop it. I also think the flip side of that coin is it's helpful to remember that the association only has so much authority. You are not enforcers of the law. And if any of that behavior rises to the level that anyone thinks it could be criminal, or if there are safety related issues, we recommend calling the authorities when appropriate in those situations. I'm going to go ahead and jump to the next question. Given that we are self-managed, or we are going self-managed, excuse me, it is likely that we will pay one of our board members a small stipend to manage the accounting, hire and support with maintenance issues, etc. What is the best legally safe way to pay this person? We could do discounted dues, which might be the most informal, or pay them as a vendor. We do have an active D&O policy. I think the starting point is you have to ask this question of your association attorney. So you cannot rely on this answer as like, oh, I've asked the question, I know what I need to do, we're going to do this right, and we're going to limit liability, and we've got it covered. Okay. So this answer is not an answer for your specific community. This is generally what we would want boards to be thinking about in this scenario. And the first thing that we want to tell you is to check with your association attorney. Often there are provisions within your governing documents that might apply. And so you want to look at what your governing documents say, and in particular, have your attorney also look at them to see if there are limitations or requirements that would apply in this scenario. I want to remind everybody that board members generally cannot be paid for performing their duties as board members, but I do realize that's not what this question about. It may be reasonable to pay them for additional services that you would otherwise pay someone else for. And if you do that, in addition to consulting with your association attorney, you want to ensure that you disclose the payments to your ownership as part of the budget ratification process. So include this information very clearly, and don't just bury it as a line item in the budget, right? Because I don't know about you guys, but I am very skeptical about, when you send out the actual budget, I'm very skeptical that your owners actually read all of those items. So put it somewhere in the cover letter. The association, since moving away from professional management last year, has decided to pay XYZ board, pay the treasurer, for example, to do bookkeeping. We shopped around and determined that this treasurer who is qualified because of XYZ background is the most cost effective, and this is the amount of money that we're paying them for 2024 in comparison to the amount that we paid our management company 2 years ago, which was XYZ dollar amount, whatever. Call it out in the budget ratification documents, because disclosures like this make it harder for owners to successfully challenge the propriety of the payments at some point in the future. As for how to handle the payments, one thing that we would also recommend that you do is consult with your CPA, but you should set this person up as a vendor. We recommend that you clarify that there is not an employer-employee relationship. This person is working as an independent contractor. The compensation is going to be reported on a 1099 to the IRS as required by law. the nuts and bolts part, like forgiveness of dues, a discount in the dues, that's the same as paying somebody. It's compensation. So as long as you're tracking the dollar amount and reporting it appropriately to the IRS, for example, that part I think is less important. Although I will admit personally to having some bias here in that I have a strong preference that that person is paying their dues like everybody else, and then they're getting a check from the association for the amount they're being paid to render those services. I think it is cleaner from an accounting perspective. And I think that it looks less like it might be inappropriate to owners who might view like somebody not having to pay their dues as unfair, but wouldn't necessarily feel the same way about paying someone for services rendered, okay? The other thing that we would strongly recommend is that you have clarity on what responsibilities are, what auditing procedures are, ways to confirm compliance with the expectations. Basically, you need to have a contract. And for that, you should have your association attorney at a minimum review whatever you write up, but probably they should have, they should actually be the one to draft the contract. And it looks like there's a follow-up question in the chat, which says, what about paying an owner, not a board member, to do work around the complex? I think a lot of the same things apply. And I think also it depends on what type of work you're talking about. If you're talking about sort of non-skilled, like handyman type work, so, you know, maybe they're weeding the flower beds or they're replacing light bulbs or doing other sort of relatively routine maintenance, I think the risk of having an owner do that type of work is lower. I still would want to make sure, I mean, like this person in the question said that they have D&O insurance, but I'd want to call my insurance company and find out, you know, if I have coverage for this type of work from an owner. And the more complex or specialized the work, the more I think it matters to have a contract, to make sure the payments are handled in the way that we just mentioned here with this question, to make sure that the person who's doing the work is licensed for whatever it is that they're doing, that they have insurance, maybe they have a bond with the state, whatever. So without getting too far into the weeds, and it depends a lot on the type of work that we're talking about, the dollar value, for example, of the amount that you might be paying the owner, et cetera. And as always, and like we said in response to this question, if you're considering doing this, you need to consult with your association attorney before you do it. Jen, did you have anything to add?
Just briefly, one thing that having a professional do work, say a professional bookkeeper, rather than a board member who has, who maybe was a bookkeeper or did some accounting for their firm, or just someone who said, oh, I'm the treasurer, I can handle this. Having a professional do it shifts the risk from the association and the board onto that professional. So having that boundary is honestly a good thing because it's less risk on the association and the board if a mistake happens. Just as an example, a few years ago, we had a client where the board agreed to let the treasurer do certain work around the association. The treasurer was paying themselves. There was no check and balance there. They were just paying themselves, wrote up their own time slips, what have you. No one was double checking. And that person took the association for a couple, for I think 5 figures. So just because you trust this person and you think they do a great job doesn't mean it's a reasonable decision business-wise. And the board has a statutory duty to act in the best interest of the association as a whole. Keeping assessments low may not be in the best interest of the association if you're taking on additional risk that you don't have to.
Jen, I wanted to add one other thing. Somebody put a comment into the chat about workers' compensation insurance. And again, without getting too far into the weeds, that's generally only if you have an employee. And our advice when having board members or homeowners do pieces of work for the association is that you make it very clear there is not an employer-employee relationship. So I just want folks to be aware of the limited applicability of that comment in the chat.
So the next question, are there any issues we should consider when making amendments to our bylaws on our own? What is the procedure for this? So we covered this rather fully at the beginning of the hour. If you missed that, it will be on YouTube in the next couple days. So paying an association attorney to do this correctly the first time saves the association time and money rather than having an association attorney come in after the fact and fix something that was done. Valerie gave an example earlier about the association that basically rescinded their declaration and any prior amendment every time they recorded an amendment. So, and we have examples of this over and over again of unintended consequences of people putting things in the wrong document so it's not enforceable. Heck, even putting rental caps in their rules, which is completely against case law and statute. So just please don't do that. Have someone, an association attorney, yeah, Valerie's laughing at me. Have an association attorney, someone who practices in this area, and it is a very niche area. Have an association attorney look over what you're doing, or heck, even just say, hey, we're thinking about doing this. Can we do it and how? Because there's been times, I'm sure Valerie has also run into this, where the board wanted to do something that maybe wasn't appropriate or statutorily correct the way they were talking about it, but it could be done in a different way and be done properly. So contact your association attorney, get their advice, have them draft the documents so you know it's done properly. You shift any risk onto the attorney rather than on the board. And it's just done. You don't have to worry about it. Ken put in a note, read the statutes and requirements for notice voting meetings, notice voting meetings, board duty of care. There are so many different statutes that apply when you're doing an amendment, and not just an amendment to your bylaws, to your declaration, because given the nature of this question, we don't know if this person was talking about the declaration or CC&Rs or the bylaws, because those two get interchanged so often. So this is not an area where you want to do something and have it come back and bite you in the rear. Valerie, did you have anything to add to that?
Yeah, I'll say two things. You know, I am a smart, competent person and I'm good at what I do. And when I need to rebuild my back deck, I hire somebody to do that who knows what the heck they're doing. And could I figure it out and watch a lot of YouTube videos and maybe do like a halfway decent job? Probably. But would I do as good of a job as a contractor who builds decks all day long every day? No, I wouldn't. And the other thing that I would like to say and sort of address maybe the elephant in the room is you might be thinking this all sounds very self-serving because we're telling you to go pay lawyers to do something that you want to do on your own. And isn't that convenient? I would like to point out that we make more money when you do it wrong and then we have to fix it. We make more money if you don't avoid litigation and then we have to step in and represent you when that happens, okay? I actually love litigation. I love almost every part of it. There's some boring stuff, the paperwork, but I like depositions. I like going to court. I like all of that stuff. And it is one of the tensions and the realities of my job that when I'm doing my job well for my clients, I don't get to do that thing that I like as often as I might otherwise. We make more money when you guys mess it up and we have to come in and fix it and clean up the mess. So we are not giving you this advice because we want the money for that flat fee amendment that we bill you. We are giving you this advice because we think it's actually in the best interest of your associations. So I'll move on to the next topic. We've got a few more questions that we had prepped and we'd like to try to get to before 11 o'clock. So we'll talk fast. Do you think that there will be changes to WUCIOA before 2028, specifically the section regarding annual audits? Instead of saying that all communities must be audited and this can no longer be waived, it would be nice if associations that are managed by a professional management company could vote to waive an audit. It seems like a waste of funds for the community to have one done annually, every 5 years maybe, but every year. So here's the answer. It is highly likely there will be changes to WUCIOA before 2028, but it is highly unlikely that the audit section will be one of those changes. WUCIOA requires annual audits for all communities, but communities with less than a $50,000 annual budget are allowed to waive it. Other communities are no longer allowed to waive it. It's unlikely that the legislature would change this section, either to raise that threshold, expand the sort of exemption or possible exemption. And we certainly do not anticipate that they would change this requirement for managed communities only, because that would be viewed as a penalty for self-managed communities. And professional management isn't necessarily feasible or the right choice for every community, not as much as we might all wish that it were. We also disagree that audits are a waste of money. And while doing them every year does represent a cost, spacing them out by 5 years makes it much less likely that the audit will actually catch and correct the types of issues that they exist to address. So, you know, bearer of the news you don't want to hear, but that's the answer. And Jen, I don't know if you have any comments you want to add to that one.
No, I don't. The next question, in advance of a special assessment budget ratification meeting, does the association need to send ballots or absentee ballots or proxies to the membership? No. If an owner submits a proxy that is valid under the statute, it must be honored, but the association does not have to provide a proxy form. You can do so if you want, but you don't have to. You don't have to provide ballots unless you're allowing absentee ballots or taking the vote via mail. But other than that, the association has no obligation to provide a ballot or a proxy form. And Valerie, I'm having a pet emergency. I'm going to go.
Go ahead. I would like to remind everybody that in the context of a budget ratification meeting, which is what this person was asking about, you can't do the vote by mail, but number one, you have to do the vote at a meeting. The statute requires that you hold a meeting and the vote takes place there. And number two, you don't have to make a quorum and you don't even have to vote to pass the budget. The way that it works is unless a majority of the voting power in the community rejects the budget, it is automatically ratified. So the default is that it's ratified. So you don't have to provide ballots, absentee ballots, proxies, any of that stuff. You're not allowed to vote by mail anyways. You don't even have to make quorum for a budget ratification meeting. All you have to do is make the required disclosures by statute, give the required amount of notice, hold the meeting, and you don't even call for a vote to ratify the budget. You essentially ask, is there anybody here that wants to reject the budget? And if nobody says anything, then the budget's ratified. If somebody says, yes, I vote to reject the budget, then you say, are there any other votes to reject the budget? And unless you get past the 50% mark in terms of your overall voting percentages, rejecting the budget, then it's automatically ratified. So in particular, in the context of a special assessment ratification or a regular budget ratification, you can't vote by mail, you don't have to provide proxies, you don't need to make quorum, and it's ratified unless a majority of the voting power in the community votes to reject it. I'm going to cover something super quickly. I've got the 2 minutes for it. This is our last question that we had prepped in advance. And this arose because we had a client that's got a contractor requesting payment of 50% of the contract sum before they start work. And the contract sum is in excess of $200,000, and the client is asking us if they should pay it. We want to remind everybody that customers take on considerable financial risk by paying contractors in advance of any work being completed. We recommend generally against any advance payment for services or materials that are not actually received on site. Washington state law does require contractors to give you notice of the substantial risk you take by paying vendors in advance and explaining to you how to protect yourself from, liens on your property and for vendors disappearing with your money. In general, financially sound contractors do not require your advance payment to pay their employees and to fund their work. And with a few exceptions, elevator replacement comes to mind. That's a very specific exception. We recommend against any advance payment to vendors. This arose because it appears that a what we would consider to have been a well-established vendor for condo associations just sort of went out of business in the last few months, leaving several clients out of pocket tens of thousands of dollars with virtually no recourse. The $12,000 bond with L&I has already had a claim filed against it in Superior Court. And so we have clients that paid deposits that are not going to get their money back because of this scenario. You can have frequent payments, such as like every 2 or 3 weeks as the work progresses, as materials are delivered. We don't think that it's unreasonable to have more frequent than make monthly invoices, for example. And one tool that either you as an association or a contractor can purchase that will guarantee work will be done is called a performance bond. If you're paying a large sum in advance, this is one of the few things that could protect you. But most clients, as we understand it, don't get these, and they don't even know that they exist. And most contractors don't qualify because there are financial qualifications that must be met in order for them to purchase a performance bond. So we are at 11:01. I apologize for going a minute late. Thank you so much for being here. We appreciate you all. We'll see you next week. Please email your questions to info@condolaw.net if we didn't get to them, and we'll be back here next week. Bye, everybody.